Hey, how you doing, Ann?
Good. How are you?
Good. Can you hear me all right?
I can. How's
All
the
right.
volume on your end? Great.
All right. Well, hey, everybody, I just wanted to share a friend of mine with y'all. She's also one of those high caliber attorneys that we need to call once in a while, make sure we stay coloring in the lines, which for those that know me know that I tend to get the crayon and try to, you know, learn my boundaries. And I appreciate, we've worked together on a few things, and I appreciate you coming on today. Her name is AnnLoGerfo, and she's with a law firm, LoGerfo Garella, PLLC, in downtown Seattle area. And you're working with me on a lot of different things, but mainly, maybe you could just kind of explain what your expertise is and just a brief description of what you're all about.
Yeah, thanks. So the law firm LoGerfo Garella is a boutique litigation firm in Seattle. We're 4 attorneys, and we particularly practice in the area of employment law and commercial litigation. So business relationships and employment law. I have a couple decades of experience in employment law and have done a lot of work with both employers and employees, so I can see things from both sides.
I bet that's helpful at times.
It is very helpful.
Well, there are a couple of things that have you've probably seen a lot in your experience with employment issues, contracts, disputes, HR. I mean, there's probably a whole host that kind of fall under that umbrella. One of the things I'd like to get right to is one of the what I would consider from an outsider looking in anyway, a drastic change in the way the law is interpreted, or the law itself, that happened January 1st as it relates to non-compete agreements. And maybe you can just kind of give a brief history of where we once were before January 1st of 2020 with that particular rule, and then now where are we?
Yeah, thanks. Probably one of the least exciting things, given all that has happened in 2020, but what would normally be seen as a major change, was a big change in Washington around the law on non-competes. So Washington is one of those states that has recognized the ability of a business to require employees or independent contractors to sign what's known as a non-compete. And so in your field, in the real estate industry, it would be the agency, the employer would have their contractors, their agents, or their employees sign an agreement. So if they left the agency, they could no longer be in the real estate business for a period of time in that same area of the state or city, county, what have you. So it's really a complete restraint on someone being able to pursue their profession, at least for a period of time. They've always had to be reasonable. You couldn't have a non-compete for the entire state, say, for the next 20 years. But if they were reasonable in scope and reasonable duration, the courts upheld them. Beginning this year, the legislature passed a statute which went into effect, and essentially it says, look, we're only going to allow you to enforce non-competes for or more highly paid anyway, employees or contractors. So in the case of an employee, the employee must be earning at least $100,000 a year in order to have a valid non-compete. And in the case of an independent contractor, and that's really, I think, what you see the most in the real estate arena, for independent contractors, it's $250,000 a year. And so absent that much income coming in during the employment or contract period, there can be no valid non-compete between the agency and the.
So it just kind of, it became unenforceable January 1st if someone didn't have in the last 12 months from the time in question, they hadn't received $250,000 as an independent contractor take home money, essentially, usually through commissions, but take home.
Right. So they're looking at actually they're looking at the 1099 in the case of an independent contractor. So, you know, there's costs and expenses that would come out after that. So it's really what's on the 1099. So sort of all in. What they're looking at is what did the agency or the business pay the employee, or what did they pay the contractor? But it's wages only, so not benefits and that kind of thing.
Right. And so that's pretty much across the board. So to keep it simple for us laymen, 100 grand if you're an employee,
Yep.
a W-2, 250 grand if you're an agent and you get a 1099. And regardless of what it says, the courts came out, or the law changed and said, no more of that. We're not going to allow you to just kind of control people and threaten people and kind of put them in a corner if you leave or else, you know, those days are kind of gone.
Now, Russ, don't forget, I do represent employers as well.
Hey, I'm an employer. I'm pushing 70 agents, man. I just have always found it interesting. I actually signed a non-compete in real estate once. I sold a firm that I owned for a long time, and it was pretty good timing, September 1st, 2008, which about 12 days later, the world changed. But one of the ways I got that particular deal done is I kind of threw myself at the mercy of a non-compete, and it was a very aggressive non-compete. And one of the parts of that, which was kind of funny, which may have been just an example of how we ended up now having non-competes that are unenforceable, because they said, hey, look, if we fire you, you can't work anywhere. If you quit, you can't work anywhere. And I'm like, wait a minute, you can fire me and I can't work? And I was like,
right, absolutely, absolutely.
But I was like, I'm signing because I could see, you know, I could see some serious great recession coming our way, and I needed all the help I could get. So I was fortunate to have a buyer, so I wasn't complaining. But 3 years
Right.
later, it was a 3-year, 3-county, under any circumstances, anything to do with real estate. And it kind of locked me up. It really did, because I ended up personally going through some challenges in that new firm with some management, and you know, we made it work. But wow, it really does. As a first time being on the other side of the coin, because historically I had always owned my own firms all the way back to 21 years old while I was in college. So I had never actually experienced too much of working for someone else. So I could see where, you know, if abused, it makes sense that it's not valid anymore.
Right, and they can be abused. And the other thing is, essentially, you know, with the level of mobility that people have right now, they really do need to be able to work at different firms, come and go. The general public needs to have the ability to hire who they want. And when you freeze people out of their own trade in a specific area, you're not only impacting that person who can't practice their trade, but you're impacting the community that can't hire that person to engage in their trade. So it's a really interesting area on restriction on competition, has a lot of issues with free trade, has a lot of issues in inherent fairness. And so where the legislature landed was, you know, if you're higher paid, you can have a non-compete that can be enforceable. There's still some other nuances to it. And the absolute longest, even with a higher paid employee, is an 18-month non-compete. But even 18 months might be found to be unreasonable. So that's sort of the max, but they may have to be shorter as well.
Right. What are some of the other issues that you see in contracts that are kind of dicey at best, or you see a lot of gray areas for potential litigation or potential abuse or just confusion, I guess, for lack of sometimes people are just confused, you know. They often sign things. I know when you order something online and they give you like the 4,000 pages and you say, hey, click this box right here. That's all you got to do. And then you can order your shirt. You know, like, what did I just sign? I have no idea what I just signed. I just want my shirt. You know.
Right. I mean, always in the area of a business with an independent contractor or an employee, you want to make sure that the way the contract is written is that it is understandable to both parties. We want to give people an opportunity to have contracts reviewed with an attorney if they want, or talk to other people about the contract if they need to. Another area that I think we're going to see some litigation in is the non-solicitation area, because with the restrictions now on non-competes, one way to control what people do after they leave your employment would be to say that they can't solicit any of your customers, can't engage with them and try and induce them to come over to the new business with you. Non-solicitation is generally enforceable, but again, it has to be very reasonable. And so, don't solicit my customers for a period of time is one thing. you can't ever solicit anybody who's ever had anything to do with my business is another thing. So I think we're going to see a lot of conversation around that. Oh, sorry.
No, I'm sorry. It's one thing about Zoom, you never can really tell. But it's like if I said, hey, everybody in the zip code you can't talk to for 7 generations, or they're my family and my estates. I mean, to take it to the extreme goofiness, that would be pretty unreasonable.
Right. That would be pretty unreasonable. That would be pretty unreasonable.
Yeah.
Yeah. And the other interesting thing that I think we'll see. Oh, go ahead.
No, go ahead. Go ahead.
I think the other interesting thing in the non-solicitation arena is what solicitation. So, you know, what does it take to solicit? If you have a website, are you soliciting people by simply having a website about your business?
Right.
You know, because theoretically you want people to see the website and ask you about doing work for them. So, you know, when we talk about solicitation, what we're really talking about is something sort of active and directed to get clients of another organization to come to you.
Yeah, and again, that interpretation, and so often, you know, in real estate, we have listing agreements, we have buyer agency agreements that kind of outline those relationships. And our area of practice is a little weird because we have agency law, which means we have a designated broker and then managing brokers and then licensed brokers, which, you know, gets pretty confusing. I remember once I was on the RCW 1885 RERAC committee in Olympia, made up a bunch of attorneys and real estate people, and they were saying, well, broker and agent is too confusing, so we decided to make it broker and broker. And I was like, did we do anybody any service there? Because I think it's more confusing now. But the point is that there's one person in each firm that really is the agent to the client. And so I guess the kind of my question is always about who's really doing what, and that definition can be very gray other than our particular contracts and our association within the MLS, which is the multiple listing service, which kind of outlines code of ethics and non-solicitation agreements that both designated brokers agree to, as well as all managing brokers and brokers under that designated broker's license. But outside of that, it's strange because you don't really know. Like, I've been around 32 years in real estate in a pretty small town. I mean, good, bad, or indifferent, somebody might have heard of me in real estate. If you do anything for 30 years in the same town, I may not be soliciting them, but they probably know, or somebody else, right? So this accusation that, oh, that has to be solicitation maybe isn't, you know, always the truth.
No, it isn't always the truth. And that's a very gray area. And certainly, you know, a non-solicitation that binds, say, one agent, if it is even binding, say that it is though, that might bind one agent for a new brokerage, doesn't bind all the other agents or that broker. That would be very specific to the one person who had signed that agreement.
If they understood what they were signing to begin with. Because if they didn't, it's all out, you know.
If it wasn't unconscionable or too vague, or there were other considerations around free trade. So, you know, there's a lot of factors that are going to go into what is solicitation and has it violated or not violated a particular provision. Yeah. Definitely.
Well, it's an interesting thing about probably in your being a lawyer, you probably experience this a lot. It's infinite, right? The knowledge is infinite and the situations are almost infinite, where you have to look at each case and go, okay, you know, what really went down? And I guess that's why every time somebody goes to court, there's 2 attorneys that believe they're right. You know, well,
those 2 attorneys are 2 parties who believe they're right. Otherwise, they would not be paying for the attorneys.
You can only imagine a judge every day going, really? Come on, you know?
Yeah, I mean, really, when you're going into court, whether you're looking at any aspect of these independent contractor agreements or these employment agreements, and whether we're talking about solicitation or other aspects as well of these agreements, what the court's going to be really looking for is fairness. You know, and good faith, and what do you have a right to protect, and what do you have a right to ask for? You know, acknowledging that everybody's an adult, presumably, in this field, and should have known what they were signing. But even within that, you know, what's reasonable to ask the courts to enforce, and really, how does it impact overall the public as well? Because there is a level of public interest in these contracts and how.
That's a great point. You know, if something is too one-sided and it's not, and it transcends the relationship between two people in business, but it affects the public negatively, that's an interesting aspect that I hadn't thought of. Hey, if you guys are interested, Ann's great. I mean, I love talking to smart people, and you're one of them, because I'm one of those guys that's always learning based. And even though I mentioned 32 years in the business, all that really means is I don't know very much, or at least I'm realizing that I don't know very much. Every year it gets bigger, and that's good. You know, that's the humility side of things, because I remember when you're in your 20s, when I was in my 20s, I thought I was all that in a bag of chips, and I knew it. You know, so every year I've realized I know less, while I'm trying to learn more. So anyway, I appreciate it. If you want to get a hold of Ann, she's got an email. It's Ann, AnnLoGerfo @gmail.com. AnnLoGerfo @gmail.com. I appreciate you, my friend, and thank you for helping us kind of take on some of these issues from time to time, and also just sharing that in the land of COVID, maybe it wasn't a big deal because it slid under the radar, but as of January 1st, these non-competes, if you're looking at them like you're worried about them, I wouldn't worry about them anymore, unless you're making the big bucks, and then you might have to.
And you might need to be worried if they're unreasonable. Still more caveats. But yeah. Anyway, Russ, thank you for the time. Always a pleasure speaking with you. I so appreciate it.
All right. Have a great day. Take care of yourself.